Good.
That's awesome.
Great. So let's go ahead and get started. It's 12:05. I want to be respectful of everybody's time. Thank you guys for all doing a small little quick 1-minute networking. It's nice to see everybody's faces that we haven't seen in a long time. So I'm going to go ahead and pass the baton over to our president, Norette Walls.
Thank you, Elise. Thank you all for joining us today. We're really happy that you all can be here for our Lunch and Learn today with Gresham Savage for transaction law. I'd like to introduce Jennifer Dorgan to you. Jennifer Dorgan has a really unique role with Gresham Savage. She is a development project manager, which gives her the opportunity to work really closely through the entitlement process and permitting process on development projects. So she's able to work with land use council, architects, engineers, technical consultants to obtain land use approvals for local jurisdictions for the developers, the investors, and the end user clients on projects that Gresham Savage is handling. So Jennifer, thank you so much for what you do there, and also for serving as our director of sponsorship for our Cru Inland Empire Foundation. And we're very happy for the work that she does there. So welcome, Jennifer.
Thank you, Norette. I appreciate that. Hello, everyone. Thank you for coming to the Lunch and Learn event. I'm excited to introduce you to a couple of Gresham Savage rock stars that handle transactions every day. While I get to be on the land use and entitlement side, I do get to work with these guys very closely to be able to serve our clients from pre-acquisition due diligence all the way to opening day. We do have here today Michael Rivera. Michael is a shareholder at Gresham Savage, where he focuses his practice on assisting clients with the acquisition and lease of commercial real property. Michael has extensive experience negotiating, reviewing, and structuring retail, office, and industrial leases, and purchase and sale agreements for improved and unimproved real estate. Prior to joining Gresham Savage, Michael was in-house counsel at Panda Restaurants Group and in-house counsel at Watt Companies, a full-service real estate development firm. The other person that hopefully will be joining us today, the other Gresham Savage rock star, is Mack Anderson. As we were talking a little bit earlier, transactions, they come up when something comes up, they need to be handled right away. So he's buried in the world of transactions right now, but hopefully he will jump on. So I'd like to introduce him anyway. Mack is senior counsel at Gresham Savage, where he works on all aspects of commercial real estate transactions. He handles acquisitions and dispositions of retail, commercial, residential, and industrial properties, as well as commercial leasing, construction, and financing. Mack advises his clients on a wide array of matters, including the purchase, sale, leasing, and subdivision of real property and the resolution of title issues. So there's our two rock stars. We're going to start with a presentation from Michael, but we'd like to dedicate a lot of the time to really questions and answers. So if you do have questions, go ahead and pop them into the chat box and we'll try to get them to you. All right, let's get started. Go ahead, Michael.
Well, thanks, Jennifer. That's a very kind introduction. How's my volume? Can you guys hear me okay? Thumbs up.
Yeah.
Great.
Good.
Thank you, guys. Yeah, I'm Michael Rivera, and it really is a pleasure to be with you guys with Cru. I know a lot about Cru just through Marlene and Jennifer and Heather. They're very involved, I know, and it's really high regarded organization within our firm. And we know there's, Jennifer uses the term rock stars, a lot of rock stars in Cru as well. So it is a pleasure to be here. Today, Kyle, if you can help me with the slides, we're talking about real estate transactions. And I certainly am not trying to make this dry, so I'll try to add as many war stories as possible. I'll start with my background. I've been doing real estate transactions law since the beginning of my legal career. I went to UCLA as an undergrad and UCLA as a law student, graduated in '06. And as Jennifer mentioned, I went straight in-house, which is unusual. Usually you need some experience before you go in-house, but it worked out because I was interning there during my law school years. And so I went to Panda Restaurant Group. You guys know it as Panda Express or Panda Inn. Love the orange chicken. But they were growing at a really, really fast rate, 20%. They were, and their real estate department was growing. And so they needed a real estate attorney. I jumped in, working on their space leases, their ground leases, some purchase and sale agreements, because they were mostly leasing property at the time. So it was a great experience. And I moved over to Watt Companies, which was in Santa Monica, where I was living at the time. And you may know Santa Monica if you're familiar with the Watt Towers in Century City. They also, at some point, had a huge partnership with Central Watt. They had a 32 shopping center portfolio that I took care of, their leasing. Then I took a sabbatical. I graduated quite young from law school. I was 24 years old. Had been working a few years and really didn't travel, and had this bug that I wanted to get rid of before I got married, before I moved too deep into my career. So I took off for about a year and a half, and I backpacked Central and South America. Grabbed a backpack, went through 15 countries. It was an incredible experience. Loved it. And it was probably the best time to go on a trip. It was actually 2009, 2010, when the economy was really bad for real estate and eventually commercial real estate as well. But I came back and joined Gresham Savage as a real estate attorney, and been here ever since 2011, and working on transactions every day. And every day is an exciting day. It never gets boring. I know most of you are in the real estate field. You guys know that the two transactions are never exactly alike. And so it's been a great ride. And so transactions has been the whole of my existence as far as career is concerned. So kind of want to break it down what transactional attorneys do. There are really two major types of transactions. It's either a purchase, so a purchase and sale agreement, or a lease. And those are the two major ones. You're either purchasing land, selling land, or you're leasing land, either as a landlord or as a tenant. You're documenting those deals. And then there's development documents, which would include CC&Rs, easements, and then other real property documents, which I guess more specifically would include grant deeds, different type of covenants on land. And so those are really the types, if we're going to break it down, that we work on a daily basis. As far as my practice, I would say right now, purchase and sales is the majority of what I've been working on. As you guys know, the world changed dramatically last March of 2020 because of COVID. And for about a month and a half, things were very different. But it seemed like everyone kind of adjusted and got right back to work. And since then, our department has been extremely busy with purchase and sales, folks buying land, I know there's some lenders as part of the group. And as you guys know, financing terms are really, really nice right now. Folks are getting loans as low as 2%, 3, 4, 5%. And so it's a good time to borrow. Folks are doing deals. There's probably more deals or less deals, and there are folks wanting to get in on them. So we're super busy. That's one of the reasons why Mack Anderson, one of the my coworkers, partners, is not able to be with us today. He had an emergency during lunch, and he was scheduled to be here. So it's quite busy. But there are also leases. Folks are ground leasing and leasing buildings. That landscape has changed. If there's brokers online, you guys will know that particularly office has taken a turn. Maybe people have additional information, but I haven't seen too much office leasing, only because people aren't sure, one, when we'll get back, and two, if when we get back, things will be a lot different. And so leasing has changed as far as office, but there's still ground leasing. There's still some space leasing, but even before COVID, retail was slowing down because of Amazon and the online retailers. So development docs, there's still a lot of development going on. Cities have slowed down. A lot of you guys are listening in from home. Cities are doing the same thing. They're working from home. And so it takes a lot longer to get development down. Jennifer works in our land use department. We have an incredible land use department here as well. But we assist them as well in transactions when they need a set of CC&Rs, maybe conditions of approval from a city. They want certain access or certain easements. We'll work on those development docs as well. And then real property docs, of course, grant deeds, quitclaim deeds, sometimes spousal transfer deeds, just anything that gets recorded of record will help with those documents as well, because now there's a lot of rules, especially in California. Documented transfer tax, what's the exception? County assessor always wants to make every recorded deed in action for areassessment. We try to avoid that when possible. So those are the things that we work on, generally speaking, from real estate transactions. Can I go to the next slide, please? So deal flow for purchase and sale, and this is, as I mentioned, the thing that I do probably primarily at this point, 75% of my time is purchase and sale agreements. It seems like daily someone's calling and saying, hey, I'm selling this piece of property, I'm buying this piece of property. And so we do have quite a large deal flow. And it usually starts like this. A broker is involved. Brokers are very, very important parties in real estate transactions. And they're the ones that really keep this industry going, in my opinion. And so a broker gets involved. They come up with a letter of intent, which usually has the basic business terms. They get us involved. They hand over the letter of intent, say, Michael, here's a letter of intent. Can you get a purchase and sale agreement ready based on these terms? And so I'll dig in the purchase and sale agreement and start inserting the business terms, which is really the easy part, but then also creating legal terms. And so what is real estate transactions? In a nutshell, real estate transactions is really allocating risk. You're trading risk. And who's going to take the risk? The buyer, the seller, the landlord, the tenant. And in transactions, when we're drafting a contract, the whole thing is who's buying the risk, or who's selling the risk, and who's going to take the risk when something happens. That's what we do when we do title review. Is it an as-is deal? Reps and warranties, super important. What happens if there's a condemnation? What happens if there's a force majeure event? And so each party is sort of allocating risk. If this happens, you're responsible. If this happens, you have to do this. And if this happens, the other party is responsible. And so you're sort of trading risks based on the amount that you've decided to pay as consideration. And that's generally what we do. More technically, we call it, we open up an escrow, we do title review, a due diligence period on the property, governmental approvals period, if that's been negotiated, negotiating the reps and warranties, and then the closing procedures. What are the conditions to closing? What are the things that need to happen before we close this transaction? And then post-closing matters. What needs to happen post-closing so that we can tie this up in a neat bow and each party go on their way. There's also different considerations when there's vacant land, unimproved, not developed, and land that's improved. Oftentimes when land is vacant, you'll have the governmental approvals period where you need to go into a city and make sure you can develop a certain property to the use that you have in mind. In California, and I assume most of us work in California or plan to work in California, vacant land becomes more complicated because entitlements are more complicated. We often do deals with clients who are out of state, and they wonder, why does it take you 9 months to 2 years to entitle a piece of property in California, where in their state it takes them a few weeks or a few months. California has what they call CEQA laws, and the entitlement process takes a lot longer. It's a lot more cumbersome, and so just a lot more work when it's vacant land. You're getting a different use, you're re-entitling. And so those are things that we have to consider as transaction attorneys. How much time does my client really need to get this entitled? How long do they have to be under contract? What are the conditions to closing? Because if I'm representing a seller, I want them to be under contract as long as possible. If I'm representing a buyer, I don't want the seller to tie up the property as long as they want. I want them to have a certain period of time. I want them to have an incentive to keep moving and either close on the property or move on, because I want to be able to freely market my property. And so those are the things that we take into consideration. So we'll get more into purchase and sales, and I know there's questions based on purchase and sale agreements, forms, and we'll answer those during the question and answer period. But that's basically the deal flow of purchase and sale. Letter of intent, I start drafting the purchase and sale agreement. I send a draft to the other side. The other lawyer takes a look, marks it up, gives me comments, trades it back to me. I take a look, I accept some comments, I revise others. We get in a call and we talk about, hey, this is why we can't accept this piece. And they say, this is why I can't accept it. We work on a resolution, and we work with our clients to get them comfortable with the purchase and sale agreement that they can enter into that meets their needs. So that's purchase and sale in a nutshell. You can move on, Kylie, to the next one, please. I think we skipped leasing. So if we can go to leasing and then we'll come back to development docs. There it is. Deal flow, very similar. Leasing is actually more time consuming and a bit more complicated relationship. Think of purchase and sale as one instance in time. I sell you a piece of property. If I draft it correctly, you close, you move on, you're the owner, and we're really not in a relationship anymore, unless maybe I'm financing the deal. But in leasing, it's really like a marriage. You're entering into a long-term relationship. The tenant and the landlord will be married for 20, 30, 40 years. And so there's a lot more to think about. There's a lot more to consider, because we're not walking away. We're not contractually obligated to be in a relationship for many, many years. And so the letter of intent, again, is the first part. The lease agreement is the parties, the rent, the business terms, but also the responsibilities of the parties. There are a lot of types. There's gross leases, net leases, modified gross leases, and I won't bore you with the details of those. But those things we consider when we're negotiating a deal. And again, you're trading risk. Who's responsible? Landlord owns this piece of property. Let's assume it's a building, and tenants coming in. That's the landlord's asset. They're allowing a tenant to use it and occupy it. They want to be sure that the structural pieces of the building are not destroyed, including the roof. They want to be sure the foundation is not destroyed. Tenant wants to be able to use the property as they see fit. And so you're just working through all the provisions. So I would say leases take a lot longer. They're a bit more complicated, and it's logical, because a landlord and tenant are going to enter into this agreement for many, many years. You need to be sure everyone knows what happens when something breaks, when something needs repair, when additional cost comes up, because you guys are in a relationship for the long term. So leases are really important. We take a lot of time with leases, probably even more so than purchase and sale agreements. So development docs, if that's the slide, we can move to that one now, Kylie. Maybe it's the one that we passed. And as I talked about, these are the CC&Rs, the easements, the temporary construction easements, development agreements. If usually with vacant land, these exist, or you're re-entitling or repurposing a piece of property, you're going to have these documents. CC&Rs, sometimes required by the city, sometimes required by the parties, but these are covenants, conditions, and restrictions. That's what CC&R stands for. Covenants on the land, what you can do, what you can do, conditions, and then restrictions. And they may include easements as well in that document. Those are pretty complicated as well, because those get recorded against the property. And so for the life of the property, unless it's terminated, that's how the property will be governed. That's sort of the governing document for the property. This is whoever owns this property moving forward, this is how you will operate. Easements are just, there's two separate landowners. They need sort of access between their properties, or to their property. You need an easement. We work on those documents as well. During development, temporary construction easements, oftentimes you need to sort of encumber some land that's adjacent. You don't need an easement per se. You just need it temporarily while you build your wall or while you build your road. And so you nicely ask the neighbor if you can enter into this temporary construction easement. So you document that. Development agreements, usually with the city, but also we deal with between, say, for example, a big retailer. We represent a few big tenant retailers who have a lot of leverage. And so they'll enter into development agreements with developers and say, you're going to build this. This is how you're going to build it. This is how long it'll take you. And depending on leverage, get into some of those agreements as well. I don't know if we have a slide for real property documents, but those are basically your grant deeds, quitclaim deeds, any kind of transfer deed that we need. Is there another slide, Kylie? Or was that it? It may have been it. Yeah, so this contact info. So if you want to go back to any of the other slides, there are a list of questions that I've been given, and I think it's I can either start with those or we can open it up. It looks like we have one already from Emily. Let me make sure I have access to chat. Emily, so is it okay if I just start with Emily's question, Jennifer?
Yes, please do.
Okay, so thanks, Emily. Emily's saying, are you seeing an influx in licensing agreements associated with outdoor patio seating? Great question. For instance, landlords not wanting to take responsibility for maintaining outdoor COVID sanitation standards for their shared patio areas. That is a great question. We have not, at least in my experience, seen that. Too bad Mack's not here. Maybe he has a different experience. But a licensing agreement associated with outdoor seating areas, that's a very good question.
And the reason I ask, I'm seeing it on a couple of my deals. I told Jennifer too, I'd love to learn more. I'm going to have to jump off early, so maybe we can catch up offline. But the reason for my question is, my client had gotten through the whole lease period and wanted to make sure she has outdoor seating and realized that all the chairs were taken from the tables that are already nailed down in the shared patio areas. They said she's totally able to occupy those patio areas, but she has to enter into an agreement basically saying that she's going to take the responsibility for maintaining the sanitation of those areas. And she was just kind of at the point where she's like, I've already paid my lawyer to look at the lease, Emily, can you fill out this licensing agreement? And obviously as a broker, I'm like, I can't advise on that. So I was just wondering if that's something that we were seeing an influx, like just a staple licensing agreement for that sort of thing due to COVID, or if maybe you haven't, which it sounds like maybe it's not that relevant yet.
Yeah, no, I personally have not. What I have experienced is that small businesses and businesses in general are really concerned about COVID liability. And that's really the issue. And so most cities have allowed restaurants to sort of a temporary permit to operate outdoors when they usually weren't allowed to do so. Some cities even have street outdoor seating. And really, we talked about allocating risk. And again, that's exactly what the landlord's doing. They want to allocate the risk to the tenant. I don't want someone getting sick, suing me. If they do, I want you to step into my shoes and defend me and hold me harmless. And that would be the landlord's position. Tenant's position would be, well, my obligation should only be to follow whatever the city requires. And if you're negligent, I shouldn't have to be responsible for that. So it would probably be somewhere in the middle where, yes, I indemnify you, landlord, so long as it's not caused by your negligence or your willful misconduct. And then that's probably where you would end up there. I know the California legislator is working on a bill to sort of waive liability for small businesses because of COVID, because everyone's afraid to operate, yet they have to operate in order to survive. And so that's a really good question, Emily. From our perspective, transactionally, depending on what side we're taking, again, the objective would be minimizing risk or shifting risk to the other side. And in this case, it sounds like the landlord would have the leverage because they're saying, sure, I'll let you use the outside patio area, but I want you to indemnify me if I'm putting on tenants counsel hat. I'm trying my best to limit that liability and saying, okay, limited indemnity in the event, that we're negligent, but if you're negligent, it's on you. So that's a good question, Emily.
Thank you.
Let's see. is that satisfactory, Emily, or do you want to? All right. So I got another one from Elise. It says, if I was acting as dual agent and principal to a transaction, would I need to disclose to seller? My understanding is that I can assign without disclosure. Ultimate goal is to dual escrow and never actually hold title myself. Second buyer is aware of my upside and on board with the deal. I just want to be sure I don't walk into a landmine with the seller by not disclosing I'm acting as principal. Good question. But when you ask an attorney, we talk about allocating risk. We are extremely risk averse. We have malpractice insurance and we have all sorts of barriers. But at the end of the day, I have found this out compared to all my other friends. I am extremely conservative when it comes to risk, and I'm extremely risk averse. And so I will always say disclose. You need to disclose. And I guess if the exact question is there a duty to disclose, I would need to dig deeper and find out more of the fact pattern. But it's oftentimes, if you have to ask the question, you should probably disclose. Now, oftentimes there's a reason why you wouldn't want to disclose, because it may ruin the deal, or it may sour the deal. And those are things that we'd probably have to discuss specifics on. But generally speaking, in a question and answer session, I would always say, hey, you should always disclose. But of course, if there's a specific situation where disclosing would either kill the deal or something of that nature, we would have to dig deep, look into the rules of ethics, make sure that we're not violating them. But in the event there's no reason not to disclose, you should ordinarily disclose. What you don't want is someone coming back after a deal is closed and saying, hey, you misrepresented yourself, or this is actual fraud, and unwinding the transaction or coming after you for some sort of delta in profit. But that's generally where we stand on that. So great question. The next one from Norette as well. Stewart Title has a long-term relationship with Gresham Savage. How important is the relationship between the law firm and title company? Are some title companies easier to work with than others? So I will say we love Stewart Title. And I'm not just saying that because Norette's online, but that is true. We work with Stewart Title. Some of our biggest clients prefer Stewart Title, and they want us to go to Stewart Title. Very important in transactions, obviously for the client as well, to have a relationship with the title company. We would like them to be responsive when it comes to opening escrow, and certainly responsive when it comes to handling title matters. That is a huge deal in purchase and sales. You want to get clean title. You want to get marketable title. It's very important. And so we have worked with Stewart Title for as long as I've been here. Frankly, they've been our go-to in our major deals because they have a great reputation, and it's really important. We work with others as well, and we know that there are other great title companies, but the relationship is important to be able to pick up the phone and say, hey, I need your help. We're closing and this title matter came up, or there's a condition and we need this or that. So the relationships are super important. You're not really closing deals without title companies, and you really want that title policy to reflect the title is clean, and a good title company that has experience is going to find a solution. Whereas we find other title companies may say, hey, there's nothing we can do. They've never seen it before. So you want to go with the title company that's seen it all. They're helpful and they're responsive. And definitely Stewart has been that for Gresham Savage. Now, another good question from Roy. In your opinion, how important is it for the broker to start the due diligence process before the letter of intent? That's a good point, a good question, and a good point regarding letters of intent. More and more lately, we have been involved in negotiating the letter of intent. And what I mean by that is that we have seen that brokers and clients want us involved before we even get into the actual purchase and sale agreement or the lease, because they want as many terms already settled in the letter of intent. And so for a broker to do due diligence, you definitely want to do as much as you can, make sure there's a viable deal. Otherwise, you're incurring due diligence costs, attorney costs, when there's really no deal to be had. And so it's important. The question is how important. In my opinion, it's important, but a lot of the things do get flushed out during the purchase and sale due diligence period. But certainly when we get a good LOI, it's easier to negotiate the purchase and sale agreement or the lease, and therefore that decreases costs for the client, and it makes it easier to waive that contingency when that time comes. So it is important. Next question from Marlene. I'm handling a litigation right now involving a double escrow transaction, and it does not look good for the realtor or the escrow company because of certain things that were not disclosed. I think that was a response to the previous question. And I think that's a good point, Marlene. It's you never want to get in litigation and find a judge who's not an expert in real estate law, knows what the clerk's telling them, but if you're being charged with failure to disclose, it's never a good thing. So I agree with that, Marlene. There are a few other questions that I received, and I'm looking at the list here to relate. One is, what is an AIR form, and what are the pitfalls of using an AIR lease or purchase and sale agreement? When should you use it, and when shouldn't you use it? So I guess, frankly, I think general consensus from real estate transactional attorneys is they don't generally like the AIR form. AIR form is just the standard form that brokers use, and it's a satisfactory form. But I think one of the things that we don't like about it is that it's meant to be one size fits all, and as we discussed earlier, one form doesn't fit all transactions. And ordinarily what we're doing is using the form, marking it up, and then adding an addendum to the back with clauses superseding the original agreement and adding provisions. And so at the end of the day, you're actually spending more time and money using the AIR form to fit it to your deal. Smaller deals, if you want to get it done quickly, maybe there's a 30-day escrow and close, you would use it. Also, we use it often for assemblages with a lot of clients who buy a lot of properties, including what are zoned residential. And then, they believe in that case, the seller will be freaked out by a huge purchase and sale agreement or a lease. And so they want to use an AIR form. So there are certain times and certain situations where we say, well, yeah, in this case, it's probably best to use this form. It's quicker, perhaps, and it's less intimidating for the particular seller or buyer, depending on what the case is. So those are AIR forms. Any questions from anyone on Zoom besides chat that wants to jump in? I don't want to miss anyone. Nope, because I have plenty here. Okay.
Michael, I have a question. Often, I know people, smaller companies and many others are reluctant to call attorneys or to hire an attorney and ask for their assistance and their advice. How do you work with smaller attorneys or brokers that are just trying to get some direction or make an introduction to you without there being a charge? How do you handle that if there's something very small that comes up?
Yeah, good questions. The answer is we take phone calls all the time. Folks cold call all the time, and I'll get the call and I'll walk them through their transaction, not completely, but ask them, what are you selling? What are you buying? Or what are you leasing? And ask them, what their objectives are. So I'm happy to jump on the phone with anyone who just needs some direction. But that's really case by case basis. There are times when we can refer them to another firm if it's a really small deal, and there are times when we can really suggest, hey, you kind of have a big deal here. You should probably get good counsel to look into this, and here are the pitfalls that you might fall into. And so we often pick up the phone or answer phone calls, and none of that's billable until you get engaged. So we're happy to talk. It's part of the process of they're interviewing us to see if we're a good fit, and we're interviewing them, the client, to see if they're a good fit. And if not, we can recommend someone else, or in the rare case, say maybe you don't need counsel. But of course, I'd be biased, but I would say most transactions do need a level of review from counsel. So there a lot more questions jumped on, or let's see if I can find, just enter Jennifer. If not AIR, what form do you suggest? I would say AIR is the go-to form if you're looking for a form off the shelf, ready to go. That is the form. I wouldn't use any other form if it has to be a form agreement. When we say we don't like it, we mean that not that we start from whole cloth, but we use our own forms that we can include the business terms, the legal terms that are necessary, the conditions. And so if it's not AIR, it's an attorney drafting your form. But if not, I think the AIR is the go-to form. And in that regard, it's probably one of the better forms. And there aren't too many standard forms, but that's the go-to. And Brad says an attorney butchered AIR form.
That joke, sorry.
I know. No offense taken. Certainly, that's always been the joke with deals. You never want to over lawyer a deal, and I'll bring that point up. And that is a real thing. People over lawyer deals. And I've always been cognizant. One of the things that really has helped me early in my career is working in-house, working at Panda Restaurant Group, working at Watt Companies. I was able to sit right next door to the business folks, the broker, the leasing agent, the principals who wanted a deal to get done. And I didn't really learn the craft from a group of lawyers. And so that's helped me to learn the art of not over lawyering a deal, where you often run into folks just wanting to negotiate, a small condemnation provision. You're working on a $190 million deal. They need to get into contract, but he wants the word reasonable in there, and you're over lawyering a deal. And it sounds like, Brad, you experienced that. So certainly we want to get a deal done. We want to work with the brokers. We want to work with the principals and understand what their objectives are, and get a deal done as quickly as possible. So you want to be known as a lawyer who gets deals done, not who kills deals. I hate it when deals die, and certainly would never want a deal to die because I was hard-headed and didn't want something and couldn't come up with a solution or an alternative. So, but it's a good point. Acknowledge it was a joke, but I do take the point. Thanks, Brad. It's a good point. So,
thank you for expanding on that, Michael. Another thing I want to see if you could expand on is extortion related to development, such as the Sierra Club, and do you guys handle that? Or maybe some of us that haven't dealt with that development or engaged with many attorneys, how do you tackle that, say, if you wanted to do your own development? Do you guys handle the extortion fees and the lawyering of that type of deal on the backside?
Absolutely. Great question, Brad. And let me get everyone up to speed. First of all, there's no one on this part of the Sierra Club online. I'm kidding.
Hopefully not.
No, what Brad's referring to is what we've seen a lot in California. I mentioned earlier that there's a CEQA process in California for development. And one of the things that is a big issue with CEQA is standing. And you'll see a lot written about standing in CEQA. Standing means that you have a right to bring a claim. You have standing, you're kind of in a position to say, hey, there's something wrong. And in CEQA, it seems like anyone has standing. And what we've seen lately, not taking a position either way, but we've seen a lot of environmental groups, a lot of union groups coming in on a development and suing under CEQA because they have standing and delaying the project. Brad uses the term extortion, and I don't think that that's wrong, because a lot of times they won't really have the environment in mind, or they won't have workers' rights in mind. They just want to check, and that's how you know it's extortion. They want to check to keep your project moving. Otherwise, they'll sue you, and even if you win, you're delayed in litigation, and your project is delayed, and time is money. So that's been a really big deal actually in California. And Brad, I'm glad you asked that question, because we actually do have quite an expertise at our firm. That's really the land use department, but we can also add the contact information for land use. The chair of our land use department is Jonathan Shardlow.
Oh, yeah.
If you want to look him up, he has a lot. There he is, right
What's
there.
up, Jonathan? We're going to get that SB 330 deal done sooner or later too.
Say it again.
Yeah, I heard the CEQA. I heard Mike trying to talk CEQA while I was walking by. So I thought I'd jump in, but I think he did better than I could. But yeah, we deal a lot with, the union suits, or, the neighbor that has a gas station trying to slow down the gas station across the street, or, just there's basically CEQA bounty hunters out there just looking for a check. So we're well versed in that. Just given that, I would say 9 out of 10 cases aren't really cases brought by real environmental interests.
Thanks, John. Yeah, that's John Shardlow. He's the chair of our land use department. That's a great question, Brad. That is a thing that arises on nearly every major deal in California. Unfortunately, the expertise is, not only do these guys know how to deal with them, these guys can pick up the phone and call the other side. They know them that well. They're sort of a mafia that's known now, and that's a great question, Brad.
Thank you. Yeah, I'm looking at Jennifer's face as you're talking. It's great. First-hand experience with all of us, huh? Yeah.
There's a lot of NIMBYs out there, that's for sure.
Yeah.
I think if we started one collectively, we could probably all make more money than brokerage and as attorneys. Just start like a new Sierra Phase 2 club.
It's sad, isn't it?
Yeah, I mean, it's pretty bad. Pretty bad.
Yeah. So those are great questions, and those relate to development in California, and that's why oftentimes clients want to get a project that's been entitled or is past that process. We've had clients from out of state who are very, very private, and their deals are confidential because they don't want anyone knowing that they're coming into town, because they know it's going to raise everyone's awareness in potential lawsuits. So Allegra Rosa, this is a great presentation, Michael. Thank you, Allegra. I have a general question. What are some mistakes you see that occur in the contract process? Good question. So in the contract process, ordinarily, if you have a good lawyer on either side, you're going to get most of the issues. But sometimes we get agreements that were drafted before we got involved, and a lot of things that are missing. It depends on what side you're on. So if you're a seller, you're selling a property, for example, a lot of mistakes include kind of releasing your liability and giving the other side enough due diligence to sell the property as is. You don't want to have any post-closing obligations. And so we see that a lot. On the buyer side, one of the things I see often is that they don't ask for the appropriate representations and warranties from the seller. You want to be able to keep the seller on the hook for repping and warranting certain things in a sale, because if something goes wrong, environmental is a big deal, because oftentimes you can do a basic phase 1, everything looks fine. You start digging deep into the property and things go wrong. And we've seen that where months, years later, there's an environmental issue, and that hasn't really been negotiated properly in the purchase and sale agreement. So no one knows who's on the hook. So those sorts of things that could happen post-closing years down the line, reps and warranties to me are important for that reason. And so those are the sort of things that we see. Also closing conditions, making it very clear, this is the closing procedure. This is what needs to happen before we close. This is what happens if we don't close. This is what happens if we don't close by this date. So that's another mistake in contract process, making very clear what the closing process is. What are the obligations of the parties for closing, and when do we close? I would say those are the big ones. Jennifer says, are there certain provisions that are often left out of LOIs, overlooked, or should be documented? Good question. I think with the basic terms, we can usually get an LOI started or a purchase agreement started, but it's always nice to have major provisions so that we're not fighting. Due diligence period is important. We want to know how long. Any post-closing obligations are important. So a lot of times someone will have a post-closing lease to be able to use the property or something of that sort. And the LOI doesn't want to address it because it's a pretty deep issue. And so it takes a lot more time for the transactional attorneys to get it done. So, things that are unique aspects of a deal should always be fully negotiated in LOI. So we're not doing it as attorneys. And anything that's a business term should be fully negotiated in an LOI, because the brokers are much better than us at negotiating those terms. You don't want us to get involved, and you don't want the other lawyer to get involved because everyone has their opinion. So it's better in the LOI to have all the business terms neatly negotiated, so we can just input them in the purchase agreement. Where you can't, then we can come up with language, but the general terms should be negotiated. So Norette says, is there a general amount for clients looking to make a purchase? I think most people are hesitant to reach out or get an attorney involved because of costs. How can we change this perception? Great question. And I think that's a big deal for a lot of clients. There are clients that are closing $100 million deals, and it's really not an issue for them. And obviously, we're always cost conscious because we're developing a relationship. But when there's a smaller deal and you don't want to spend all your money on legal fees, there are times when we can make arrangements where we'll create an initial draft and that's it. And you really want a good contract to start with, and they're willing to move forward with the rest of their deal. And we can come up with a sort of a ballpark fee, anywhere from $2,500 to $5,000, but be very clear in the engagement that we're only drafting an initial contract. Anything after that, we would have to enter into an additional scope of work letter. But I think it's important, and think of it this way: if something goes wrong, just for litigation, you're going to spend more than that just to get an attorney to answer his phone in litigation. So it's a good insurance policy for your deal.
Can I ask a follow-up question for that? I think some people will make the comment basically that, well, I have a broker. Why am I engaging them and paying them a fee if I, on top of that, need an attorney to complete the job to finish? Now, I don't always think that it needs to be looked at in that manner. I think they play two separate roles completely, and both keep you out of court and out of jail.
Right. And it's important to note, and I mentioned before, brokers are very, very important. And obviously they play a major part of the deal, but their objective is to get the business terms right. And as we talked about, the purchase and sale agreement, it needs to be thought of as there's business terms and legal terms. And ordinarily you'll see it during good times. And right now I would say we're in good times when it comes to real estate transactions. And I say that with a sensitivity, knowing that we're still going through COVID. I don't mean that we're in good times regarding COVID, but good times regarding real estate. People are buying and selling like crazy, and it seems like they're making money. And so it's often very easy to say, I don't need a lawyer, I'll take the risk. And then it's in bad times when the economy kind of dips with regard to real estate that you kind of realize, hey, I wish I would have had the legal terms, the remedies, the default sections tied up. So those are great questions. And it does just take a phone call. We're willing to speak to people and just let them know, this is why we think you need an attorney, whether it be us or someone else for this deal. Here are some of the pitfalls that you may find as you move towards closing. So thanks, Norette. There are a couple of other questions here. One is, at what time in the deal process should I get an attorney involved? As I mentioned earlier, more and more we're getting involved in the letters of intent, but traditionally our first contact is with the client or broker handing us a LOI. And so that's really the time that we would get involved. But again, we can get involved sooner during the LOI stage to try to knock out some of those terms as well. But certainly never good when someone hands me an already signed purchase agreement, missing a lot of important terms, and they're saying, we're closing next week, can you help me? But we will help you, but it'd be a lot better to get us involved a lot sooner. So we have about 3 minutes. I think we'll take this last question, which I think is there one thing you helped a client achieve that stands out in your mind as a major accomplishment? Great question, Jennifer. I will say I have very high job satisfaction. I love real estate. I love transactions. And so I can't think of one in particular, but it is a great feeling to know when your client acknowledges, hey, that was a big hurdle that you jumped. Thanks for finding that alternative solution, or thanks for pointing that out. We didn't think about that. And anytime we can help our clients, and it happens often, get to closing, close the deal, and get them the outcome that they want is a great feeling. I love it. I've been doing this again my whole career. Real estate transactions every single day is a fun day. Working out problems, and not to sound cheesy, but every day to me is a major accomplishment because we help clients every day. But I love it. I love it. And oftentimes lawyers will tell you, don't go to law school, you'll hate it. I say, if you want to go to law school, go to law school. If there's anyone still considering that, but most of you are real estate professionals already, it's a great industry, great field, and I love it.
Thanks, Michael. I appreciate it. I certainly enjoy working with you and the benefits that you help the land use team achieve. Before we wrap it up, I'm just going to pass the baton over to Norette. I think she has some final words, and we'll let you go off on your day.
Thank you, Jennifer. So Jennifer came up with this great idea to have this actual event that we're having today, and a conversation that she was having with me couple months ago, actually. So it took a little while to put this on the calendar and get it together. And I want to thank our programs team for making a great event today. Elise and your team do a great job. Thank you, Michael. Thank you, Jennifer, for coming today and spending your time with us and sharing information. It does help everybody in their business day to day when they're learning something. So that is very, very thankful for your time today. And we thank Gresham Staffage for being a great sponsor and supporter of Crew Inland Empire and all the events you do for us. So thank you very much. We appreciate that. We thank you all for attending today, and we hope to see you soon. We're going to be having our next event is going to be our high performance negotiating skills for women. That's going to be February 23rd via Zoom. It's next Tuesday. So if you haven't signed up for that, please do so. And we're going to be having our first in-person event of the year coming up in March. So details on that to follow. Thank you all for attending, and everyone have a wonderful day.
Thank you.
Thank you,
everyone.
Thank you, everyone.
Jennifer, Is it okay if we share the slide with guests?
Yes.